whether you wear a badge or not. If you care about courage, clarity, discipline, and the price of decisions in the moment that define lives, you've come to the right place. This is where training meets consequence, where the law collides with human behavior, and the fog of uncertainty tests the limits of reason. These are the stories of pressure, of purpose, and what it means to hold the line when the world loses balance. I'm Don, a police officer, instructor, and founder of Forecast Securities Group, and I'll be your guide through the storm. Welcome to the Conditions Report.
Hello, and welcome back. I'm glad you're here. If this is your first time joining me, here's what this show is. The Conditions Report is a weekly series where we take a structured look at policing the way a pilot looks at the sky. Every episode, we cover the statutory climate, the laws that set the baseline, then we look at the legal fronts, the cases that test those laws in real life. We move into the leadership climate, the principles that you can carry into the field, and we finish with an extended forecast with lessons that can bring you into the work week ahead. The idea behind the show is simple. Policing is not random, it's an environment. And in that environment, everything can change. Just like the weather, the legal and cultural atmosphere around the job can shift and shift quickly. If you can't read the sky, you're going to get caught out in the storm. And the goal here is to give you the tools and context to forecast those shifts before they hit you. The Conditions Report is part of The Forecast, a project by Forecast Securities Group, LLC, a training and consulting company I founded. We help professionals operate with clarity, legality, and precision in high-risk environments. And every week, we take a piece of the law, a case, or a leadership problem, and we break it down so that way you can not only understand it, but use it in the field. Before we begin, here's the disclaimer. This podcast is for educational purposes only. It is not legal advice. I am not an attorney, nor am I acting as one. I do not represent any government agency or department, and I speak only on behalf of Forecast Securities Group, LLC, the training and consulting company that I founded. If you're dealing with a real case or a real incident, always consult legal qualified counsel. All right, so let's get into it. The statutory climate this week starts where all discussions of search and privacy begin, with the Fourth Amendment to the United States Constitution. It reads, "The right of the people to be secure in their persons, houses, and papers and effects against unreasonable searches and seizures shall not be violated, and no warrants shall be issued but upon probable cause supported by oath or affirmation, and particularly describing a place to be searched and a person to or things to be seized." That one sentence defines nearly everything about the limits of government power. In short, but it's packed. It tells us that two things. First, that the people have the right to be secure, and second, that the government can only intrude with justification and precision. Those words were not written in a theory. They were born out of the abuse the founders had lived under when they were under British rule, where general warrants allowed soldiers to search anywhere, seize anything, and harass anyone. The Fourth Amendment was designed to stop that forever. It names four specific interests: persons, houses, papers, and effects. Persons means your body, your privacy, and your freedom of movement. Houses means your home and the immediate area around it, what the courts like to call curtilage, where your life happens without intrusion. And papers means letters and ledgers in the 1700s, but today it includes things like texts, emails, and the digital record of your life. And effects is a catch-all. It's property, possessions, and everything that defines you as a person in your world. Every Fourth Amendment question begins with the same core inquiry. Did the government intrude on any of those protected interests? And if it did, the next question is whether that intrusion was reasonable. Reasonableness usually starts with a warrant. A warrant is the government's permission slip, but it only works if it's earned properly. It must be based on probable cause, supported by oath or affirmation, and has to describe exactly what is to be searched and what is to be seized. Probable cause is not a hunch. It's a fair probability based on specific facts that evidence of a crime exists. The particularity requirement forces precision. It prevents general searches and guarantees accountability. And the oath requirement demands honesty under penalty of perjury, which is a forgotten but essential piece of the process. There are exceptions to the warrant rule, but each one is narrow. Consent, for instance, when freely given by somebody with the authority to give it. A search incident to arrest to prevent destruction of evidence and to protect officer safety. Exigent circumstances when time or danger won't allow any delay. The automobile exception because cars are inherently mobile and heavily regulated. Plain view when something criminal is visible from a lawful position. And Terry stops based on the reasonable suspicion for officer safety. Inventory searches to protect property and prevent claims against government entities, and administrative or special needs searches used for public safety or regulatory enforcement, but not criminal investigations. Each of these narrowly defined exceptions comes from a case where officers acted, the defense challenged, and the court drew a boundary. Together, they form a living law of search and seizure. Each court's tied those boundaries to property. In Boyd, the courts condemned forced production of private papers. In Olmsted, it upheld a wiretap because there was no physical entry. Privacy at that point lived in bricks and fences. But as technology has advanced, the law had to evolve too. Silverman struck down a spike microphone that penetrated the wall. Berger invalidated a New York eavesdropping statute for being too broad. And then came Katz v. United States, the case that changed everything. Katz took the Fourth Amendment from property to privacy. Before 1967, the rule was simple: no trespass, no search. If the government didn't physically cross a boundary, the Constitution didn't apply, and Katz broke that logic. Charles Katz was a bookmaker working out of Los Angeles. He used public payphones to call clients in Boston and Miami, and the FBI suspected him of interstate gambling. They installed a small microphone on the outside of the booth he used. They never went inside, never tapped the phone line, and never touched private property. From their view, there was no intrusion. At trial, Katz argued that his privacy had been violated. The government said no. He was in a public place using a public phone, so there was no expectation of privacy. The question reached the Supreme Court. Can the government record a private conversation in a public place without a warrant? The court said no. Justice Potter Stewart wrote, quote, "The Fourth Amendment protects people, not places," and that sentence became the turning point in American law. The majority held that what matters is not where you are, but whether you sought privacy. When Katz closed the door of the booth, he showed intent to keep his words private, and society agreed that that expectation was a reasonable one. Justice Harlan's concurring opinion gave the court's framework that it still defines as quote-unquote a search under the Fourth Amendment. It became known as the Katz Test, a two-part standard that asks two questions. First, did the person exhibit a subjective expectation of privacy? In other words, did they personally intend to keep something private? Katz did. He walked into the phone booth, closed the glass door, and spoke in a lowered voice. Those actions showed that he believed his words were not for public consumption. The first prong is about intent. It asks what steps the individual took to separate the private from the public. Second is that the expectation is that one of society is prepared to recognize as a reasonable one. That's the objective side of the test. It moves the question from what the individual believed to what the public generally accepts as fair. Society agrees that people have privacy in their homes, in their bedrooms, and in their personal communications, where they have taken steps to secure privacy. Society does not extend the same protections to things left in plain view, like trash left for collection or conversations shouted in public. When both prongs are met, when a person actually expects privacy and society agrees that the expectation is legitimate, government intrusion crosses into the territory of a quote-unquote search. From that point forward, the Fourth Amendment applies, and the usual rules of probable cause and a warrant procedure govern the action. The power of the Katz test lies in its flexibility. It protects privacy not by physical boundaries, but by human behavior and social understanding. It adapts as culture and technology evolve. Whether the issue is a phone booth in 1967 or a smartphone in your pocket today, or data stored in a cloud tomorrow, the same two questions still decide if the government has stepped over the constitutional line. Katz didn't win because of walls, he won because of the intent. He did what any rational person would do to keep a conversation private, and the government ignored it. Listening to a loud conversation in a park isn't a search, but using technology to hear what a human ear could not is. And Katz wasn't about cutting lines, it was about listening from the outside. The decision reshaped policing. It told law enforcement that technology doesn't replace probable cause and that the Constitution must evolve with the tools of investigation. Privacy, the court said, is measured by conduct, not geography. The leadership climate this week is built around a single truth. Police power is held in the public trust. Every ounce of authority we have comes from the people, not from the badge, not from the department, not from the chief, and not from tradition. The laws we enforce, the powers we carry, and the limits we operate within all come from the public's consent. That consent is not permanent. It has to be re-earned and renewed every single day through honesty, restraint, and legality. When we act without knowledge or with arrogance, we weaken the trust. And when the trust is gone, legitimacy follows closely behind. The badge can become a decoration, and power can become an illusion. To wear a uniform is to inherit the weight of those who walked before us. For instance, Bass Reeves, who was born into slavery in 1838 and became one of the first black deputy U.S. Marshals west of the Mississippi. He rode thousands of miles through Indian Territory, enforcing the laws with no backup and no prejudice. He made over 3,000 arrests, and his reputation was unmatched. When his own son was wanted for murder, Reeves took the warrant himself, arrested him, and turned him in. That is what fidelity to the law looks like. Wyatt Earp stood at the intersection of law and vengeance. The OK Corral made him famous, but his legacy is a complicated one. After his brother's murder, he led a posse that hunted the suspects down, some of them dying under his own badge. Justice and revenge blurred. And he reminds us that courage without restraint becomes chaos. The hardest thing in policing isn't necessarily always acting, it's knowing when to stop. Eliot Ness faced organized corruption on a scale most of us will never see. Al Capone owned Chicago, and the system was on his payroll. Ness built the Untouchables, a group of agents who could not be bribed. They didn't rely on intimidation. They built cases with ledgers and evidence. They took down a criminal empire without losing their integrity, and Ness showed that law enforcement's greatest strength is its endurance under pressure. Frank Serpico fought corruption from within as well. New York in the late 1960s was soaked with payoffs. Serpico refused to take a dime. When the system ignored his reports, he went to the press, and for that he was nearly murdered. On a narcotics raid in Brooklyn, he was shot in the face when his backup didn't enter. He survived and testified before the Knapp Commission and forced the first major reckoning in modern policing. Serpico proved that loyalty to the oath outweighs loyalty to any organization. Each of these men carried different lessons. Reeves showed that duty bound to consciousness. Earp showed that the cost of unrestrained power, and Ness showed us the integrity under pressure, and Serpico showed courage of moral clarity. Together, they teach that authority isn't ownership, it's a stewardship, and the permission to act in the name of others is renewed only through lawful and honorable conduct. Katz v. United States brought us the very same message, but it transferred it into the legal realm. It reminded law enforcement that power has boundaries, even the unseen space of privacy. The badge gives authority, but not exemption. The extended forecast this week is simple. Technology keeps changing, but the principles do not. The Fourth Amendment protects people, not places. That means that every new tool, drones, digital data, GPS, cell tracking, must still live under the same old rule, reasonableness. Just because we can reach further doesn't mean that we should. The measure of professionalism is not capability, but control. Every time you act under the color of law, you're drawing from borrowed authority. The people trust you to know the law, respect it, and work within it. That trust is your true credential, and it's the only thing that makes this profession a legitimate one. That's the forecast. I'm Don, and this has been the Conditions Report, Episode 4, Inside the Booth, the Katz Test. Be the calm in the storm, the clarity in confusion, and always influence the weather. We'll see you next week.